So we haven't been able to prepare for that. It wasn't in the skeletal argument sent to us. And the second point is that the case used was from 2007, R versus X head teacher's case, which I have given a copy to the clerk, so that you will notify that we will not be addressing that point because the case takes place in 2006, and we were not unable to use cases past 2006.
That's probably quite fair. Can't use future cases.
Sorry, who was using a future case?
The appellants had used a case from 2007, and they also, there's no mention of the Ministry of Agriculture in the printed version of the skeleton argument that we have here.
So we haven't prepared the 2007 case?
R versus X head teachers, or R versus Y.
So it was or wasn't prepared to?
They referred to it, but we were unable to rebut this case because I had made them aware of this before the My Lord, also I'd like to...
So there's more.
Why did you tell me that? Why don't you hear from you?
As my Lord, it was a procedural error. When we were writing down the citation, we took the wrong one, and we didn't realise it was too late last night.
And they did bring it up to my attention before their submissions.
So it's the one in paragraph 3 that should be 2007, should it? In your skeleton.
Page 5 of the amendment.
I'm saying it is a case in 2007.
Yes,
The summary only takes place in 2006.
My Lord, may I make a further point that in our skeleton argument we have listed 9 or possibly 10 cases. When I was notified of this, I reduced my submissions to 5 as per. I was told that was the rule, so I have reduced my submissions.
Thank you. You're correct to bring that to our attention. Thank you.
Thank you very much. May it please your Lordships, I'm Hannah Malik, together with my learned friend Martina Lindblad, appearing on behalf of the respondent in this matter, Ms. Martin. Would your Lordships like to be reminded of the facts of the case?
No, thank you.
I'm obliged. My Lords, I shall be addressing the first ground of appeal, and the second ground will be addressed by my counsel, Ms. Lindblad. My Lords, before I move on to my submissions, may I confirm that your Lordships have received a copy of the respondent's skeleton argument and its bundle of authorities?
Yes.
I'm obliged. I intend to address your Lordships firstly on the issue of the creation of a substantive legitimate expectation by way of an express promise, the residing from which amounted to an abuse of power. Secondly, I will address the requirements of proportionality in line with the principles of fairness and good administration, which are the grounds for departing from legitimate expectation, and submit that this was not fulfilled in this case. Thirdly, I'll address the notion of Wednesbury unreasonableness, which denotes that a court may intervene when factors that ought to have been taken into consideration have not, namely the distress caused by the adherence to the uniform, resulting in taunting. If I may now turn to my first submissions, my Lords.
Please do.
My Lords, it is submitted that where a public authority either makes an express promise or implicitly creates a sense of continued practice, that representation gives rise to a legitimate expectation on behalf of the representee that the public authority will give effect to that promise. There are 2 forms of legitimate expectation, my Lords, procedural and substantive. Procedural encompasses cases where there is an express promise to consult before a decision is taken. Substantive legitimate expectation, the area of concern in this case, arises where an expectation is that the public authority will act in accordance with its representation as a matter of substance. My Lords, it is submitted that a substantive legitimate expectation was created in the representation made in writing by the appellant in which it is stated. I guarantee that you will not be required to wear the standard college uniform, i.e. the pink and green tartan skirt. You will be permitted to wear a white blouse with black or grey trousers instead. It was upon this promise that the students rejected their offers from the other schools and accepted their place at Pegswell College. My learned friends representing the appellant have given an account of why they do not believe a legitimate expectation was created. It is premised on 3 factors. Those are the promise being lawful, unambiguous and reasonable. My lords, the promise made by the appellant to the respondent was all 3 of these factors. It was lawful, it breaches no law, it is clear, and indeed it is a reasonable promise. My lords, there is precedent for people being allowed to wear a uniform that deviates from the standard uniform. For example, for cultural reasons, some girls are allowed to wear trousers instead of skirts. So I cannot understand why this would be unlawful in this case.
But this wasn't cultural or religious.
Yeah, there weren't any reasons, were there?
No, my lords, I completely agree. It's not a cultural reason, but it doesn't deviate from the law, because if it did, I'm sure there would be a prohibition. It would be prohibited for schools to do that for cultural reasons as well.
Can enlighten us? It says that he replied in writing to all 17 students on the 5th of July. Are you aware on what basis he did it, whether it was on school notepaper, was it by email? Are we aware?
Well, in the facts of the case, I haven't been made aware of how, but I would presume that in writing possibly could be by a letter, but I couldn't go further because I'm not aware directly. May I continue with my submissions?
Please do.
In Ex parte Coughlin, which can be found on pages 2 to 3 of your bundle, Lord Justice Wolfe states, where a court considers that a lawful promise or practice has induced a legitimate expectation of a benefit which is substantive, not simply procedural, authority now establishes that here too the court will in a proper case decide whether to frustrate that expectation is so unfair to take a new and different course will amount to an abuse of power. Here, once the legitimacy of an expectation is established, the court will have the task of weighing the requirements of fairness against any overriding interests relying upon the change of policy. My lords, on the issue of fairness, in Ex parte Unilever...
Just on the position of abuse of power, are you seeking to persuade us that something which doesn't appear to amount to discrimination could be an abuse of power?
My lords, I do believe that in resigning from a creation of a legitimate expectation, that the appellants did indeed his actions did amount to an abuse of power.
So merely opening up your clients to some teasing would be enough, because that might give rise to a lot of disputes of this nature if that threshold is quite low.
My lords, it is submitted that perhaps that this was in the interest of the appellant before making a promise to the students, not after. May I continue with my submissions? Thank you. My lords, on the issue of fairness, in Ex parte Unilever, available on page 1 of your bundle, Lord Justice Brown states, it is illogical or immoral or both for a public authority to act with conspicuous unfairness and in that sense abuses of power. My lords, the respondent and her fellow students were given the representation in writing that they would be exempt from wearing standard uniform. This was not for any frivolous reasons, such as a fashion statement. My lords, it was to avoid being the subject of ridicule and taunting, which precisely what other students who had worn the uniform had experienced. This is an issue of mental well-being and safety. It is submitted that the departure from the legitimate expectation did amount to conspicuous unfairness. To make assurances as to the mental and physical well-being of a person or group of people and then to depart from those assurances.
What do you think the mental and physical well-being would have been if these students, had they been allowed to dress differently in the school and have the majority of girls feeling quite upset that they have to wear this horrid uniform while these 17 get to wear trousers and shirts? Do you not think it would have resulted in some sort of instability within the school and possibly mental trauma for these girls, perhaps being hounded by the majority of girls?
My lady, that is an interesting point. What I believe is that the concern here is that these girls were in fear of being taunted and ridiculed, and that if the headmaster did indeed care about the mental well-being, he would perhaps understand why so many students were asking to be exempt from the standard uniform and address that, because indeed a bright green and pink skirt is the issue, not necessarily the deviation from the uniform. May I continue with my submissions? Thank you. If indeed there is a conflict of interest in allowing certain students to wear one uniform and others wishing to do the same, perhaps a remedy would be to consider the reasons why so many students wish to wear the alternative uniform and allow them to do so along with the students who have been promised so. However, a conflict of interest between two parties does not constitute an overriding public interest or an issue that is in contrast with government policy. My Lords, it is submitted that the decision to resolve from the substantive legitimate expectation without notice on merely a presumption that disciplinary problems would arise does not meet the balance of fairness criteria and thus constitutes an abuse of power. My Lords, may I move on to my next submission? I'm obliged. It is submitted that the appellant did not meet the requirements of proportionality in the decision to resolve from the substantive legitimate expectation that was created. The proportionality test, arrived at by Lord Justice Laws, observes that the principle of fairness and good administration, in which the concept of legitimate expectation is rooted, are akin to those found in convention, such as the right to fair trial and no punishment without law. In light of this similarity, Lord Justice Laws notes that residing from legitimate expectation should be the subject to the same scrutiny as interference with convention rights. My Lords, the test of proportionality is summed up in the Nadaraj case, available on page 4 of your bundle. Accordingly, a public body's promise or practice as to the future conduct may only be denied, and thus the standard I have expressed may only be departed from in circumstances where to do so is the public body's legal duty, or is otherwise, to now use a familiar vocabulary, a proportionate response, of which the court is the judge or the last judge, having regard to the legitimate aim pursued by the public body in the public interest. The principles of good administration require public authorities to be held to their promises, would be undermined if the law did not insist any failure or refusal to comply is objectively justified as a proportionate measure in the circumstances. Furthermore, on page 5 of the bundle, Lord Justice Law states that proportionality will be judged by the respective force of the competing interests arising in the case. Thus, where the representation relied on amounts to an unambiguous pure promise, where there is detrimental reliance, where the promise is made to an individual or specific group, these are instances where denial of expectation is likely to be harder to justify as a proportionate measure. On the other hand, where the government decision maker is concerned with raising wide-ranging issues of macro-political issues of policy, the expectations enforcement in other courts will encounter a steeper climb. Excuse me, my Lords. My Lords, the promise which created the substantive legitimate expectation was made to a group who indeed had a detrimental reliance in determining whether they would accept their place at school. There are no macro-political issues involved, such as those in the GCHQ case, where it was an issue of national interest. Which comes under the scope of macro-political interests. My Lords, it is submitted that this is not even an interest of public interest. It is noted that where indeed a few complaints by other students, however, were not indicative of disciplinary problems, and again, if these students were to have caused a nuisance for the appellant, that would be an issue of two competing private interests. One could even say it is more of an issue of the appellant's interest with regards to convenience rather than public interest. My Lords, may I please have a sip of water? My Lords, it is submitted that the appellant made the more convenient choice for his own benefit. This does not constitute a proportionate reason to resolve from a legitimate expectation. My Lords, may I move on to my final submission? I'm obliged. The doctrine of Wensbury unreasonableness, derived from the Wensbury case available on page 6 of your bundle, denotes that a court may intervene where a public authority have refused to take into account or neglected to take into account matters which they ought to take into account. My Lords, it is submitted that the appellant refused to take into account the acute distress young women face when they are taunted and ridiculed. In this instance, the reason was the adherence to a uniform imposed by Bexborough College.
Well, I'm not sure they're saying that it's fair to say they didn't take it into account. Their point is they had two options. One was to go down that road or to go down the road of what they considered would be discrimination, and they chose the lesser of two evils.
So isn't it a case that they positively weighed up the options and had to come to one conclusion or the other, and came to the conclusion which they felt was the appropriate one? So it wasn't a case of just ignoring the options, was it?
My Lord, I appreciate that argument. I would actually submit that it was a case of ignoring the distress, because had they had the option, they could have perhaps had another option of allowing the students who disagreed with the uniform or felt under the same position of distress to adhere to the new uniform that the 17 students had been made available to. If indeed the school had an interest in the distress of these young students.
Thank you.
May I move on to my speech? Thank you. I may now refer to the Wednesbury case, also available on page 6. Once the local authority had properly taken into consideration a matter of public interest, such as in this present case the moral and physical health of children, there is, it seems to me, nothing which Atkin Day says to suggest that the court could interfere with the decision because it took a different view as to what was in the public interest. My lords, the applicant did quite the opposite. In resigning from a legitimate expectation to be allowed to wear a uniform that would attract ridicule and insults, the appellant did not take regard for the moral well-being of the respondent and peers. It further demonstrates a lack of detailed thought towards the extraneous factors that should have been taken into consideration as set out by the notion of Wednesbury unreasonableness. My lords, in summary, there was indeed a creation of a substantive legitimate expectation. The decision to resolve from the legitimate expectation was not a proportionate response to a matter of public or macro-political interest. And finally, extraneous matters which should have been taken into consideration were not. If I can assist your lordships any further, these are my submissions.
Thank you very much.
One thing. It seems to me that there's almost an abuse from the perspective of these girls. I mean, they had a choice of several colleges. They chose to use that power of choice between different schools to bully the principal into giving them a different uniform. Now, we know the pressure on schools to keep their numbers of students up, to attract high-performing students, and we know also the sort of increasing political impetus to insert choice into the matter of education. Now we see here, possibly we could read this case an example of where choice can be abused in this manner. Here we have these girls saying, look, unless you let us dress the way we want to, we're going to go to a different school. Do you not see this as somehow actually the public interest we should be taking into account is perhaps protecting schools' establishment and making their own judgments as regards uniform, and not be allowed to be bullied into changing things according to the particular students' preferences as what to wear on what day? Who knows what they would turn around and say, you know, students entering the next year would say they want or demand if they're to accept a choice of place at school.
I appreciate that point, my lady. My response would be that the school had every opportunity to deny them that right, and they decided not to for their own reasons. And on that reliance of the promise, these students decided to attend the school. Indeed, it would appear that it was their preference to attend this school, but only on the condition that they would not be the target of ridicule. Had the school not wanted to make students exempt, they could have refused immediately, and therefore these students could have attended a college where they felt more comfortable in the uniform.
Okay, I don't think you've quite dealt with my point about the pressure on schools. But